Good morning, everyone, and welcome to our webinar this morning, which is Return to the Office, the Old Norm. This is the second in the series of webinars that we are running this autumn in place of our usual in-person Think House Foundation events. My name is James Hall. I'm one of the co-chairs of Think House Foundations here at Gowlings. I'm a senior associate in the employment team. As you have joined us for the webinar today, hopefully you know that Think House Foundations is our program aimed at in-house lawyers at the more junior end, ranging from trainees and paralegals up to lawyers at around 5 years PQE. Hopefully you were able to dial into our webinar yesterday morning, which was a litigation survival guide delivered by our colleague Anna Lelliot. If not, then we will be sending around a recording of that webinar, so please do keep an eye out for that. And in this series of webinars, we have another one tomorrow morning at the same time, which is Hot Topics in Data Protection, which will be delivered by our colleague Claire Van Ristel. So hopefully you can join that one live tomorrow morning, but if not, that one will also be recorded. So on to today's topic, Return to the Office, the Old Norm. I'm joined by Jasmine Coyne, my teammate in the employment team. She's an associate here based in the Birmingham office. And Jasmine is going to take you through some of the risks regarding the return to the office and offer you some practical tips and takeaways to be thinking about to address those risks. We're also going to have a quick poll at the beginning of the to get an idea of your personal thoughts on returning to the office. Hopefully you'll agree that return to the office is a real hot topic at the moment. It's been in the media lots with COVID-19 restrictions easing and the government's move away from sort of, work from home instruction where possible to getting back into the office. Although I'm conscious that the news this morning was saying that we might be going on to Plan B. So we'll see where we get to. But for the moment, hybrid working is the sort of new norm. I'm obviously an example of this today as I'm in the office. Jasmine's working from home, but I was working from home yesterday and Tuesday as well. So there's lots of practical challenges regarding this, as well as some legal ones too that we're going to talk through today, or Jasmine's going to talk you through today. So yeah, Jasmine's going to speak for around 35 minutes, and then we'll have some time for questions at the end. And we'll look to draw the webinar to a close at around 11:15. Before I hand over to Jasmine, I just want to run through a couple of housekeeping points. The first one is if you'd like to ask a question, then we are using the Q&A function on Zoom, which you'll find at the bottom of your screen. So if you click on that and then type in your question, it will be directed to Jasmine and I only. So none of the other attendees will see the question, and we really encourage questions, and there's no such thing as a silly question. So please do put any that you think of in the Q&A, and we'll do our best to get to them all before we finish today. If not, leave us your contact details and we'll certainly follow up with you. And secondly, the webinar will be recorded. Hopefully you've had the notification as well, say that. So as I mentioned earlier, we'll be sending a recording round, so feel free to share that with any colleagues that you think might find it interesting or useful. And then finally, we'll be sending around a link to a feedback form at the end of the webinar, and hopefully that if you've got a couple of minutes just to complete that, we really appreciate it. We do read them and they do shape future sessions and topics. So yeah, if you could do that, then we'd really appreciate it. If you don't have time now, it will also come around in the link with the recordings. So yeah, if you could do it then, that would also be great. So without further ado, that's enough from me, and I'll pass you over to Jasmine.
Thank you, James. Good morning, everyone. As James has said, I'm going to look at the issues affecting companies that would traditionally operate out of offices and the legal considerations that may arise as people are required to return to the office. Working practices have changed a lot since the onset of COVID, and I think we can expect to see a more blended approach to being in the office and working from home. But before we get into the full discussion on that, I'd like to run a quick poll just to gauge how you're all feeling about returning to the office and what your preferences would be. So a question should appear on your screen shortly. And the question is, how many days each week would you all like to be in the office? So you can choose 0 days, you much prefer working from home, 5 days, you absolutely love being in the office, or perhaps you're somewhere in the middle. I'll just give you a few moments to have a look at that, make your decisions, and then we'll take a look at the results. Okay, I think we'll take a look at the results now. Hopefully you should be able to see that there's actually quite a mix of output of results, but there's more of a skew towards staying at home. I don't think anyone's said they'd like to be in the office full time. I think really the different views, the different opinions held by individuals really creates a balancing act that employers need to tread, because employers need to remain attractive to their employees, but at the same time, they need to balance the needs of their business as well. Okay, so the topics we're going to discuss today then, it may be that you haven't brought your employees back to the office yet, or it may be that you will be bringing employees back in a couple of months' time. But I think the issues we'll discuss today can arise at any time. So we'll be taking a look at what employers can do if employees don't want to return to the office. We'll run through some of the scenarios that employers might face and what the legal considerations are. We'll take a look at flexible working requests and have a reminder of what they are and what employers need to be considering when they receive flexible working requests. And then we'll finish by discussing a few of the hot topics that we've been receiving queries about in our offices or in our team recently, in the hope that by tackling these, you might be answering a few of the queries that you're facing in your businesses at the moment. So moving on to our first topic then. The question here is, can employers require employees to return to the office? And the starting point, the first point to consider is what the individual's contract of employment says, because every employee's contract of employment should have a stated place of work in it. And that may be their employer's offices in London, it could be their employer's offices in Birmingham, or it could be their home address. But if their stated place of work is their employer's offices, then employers can expect that employees will return to the office when requested. And in principle, if an employee refuses to return to their stated place of work, be in the office, then that employee would be refusing a reasonable management instruction, and then the employer may choose to take disciplinary action against the employee if they see fit. But really, before employers go down that road, they really should be considering why the employee doesn't want to return to the office. This is just to kind of understand the reasons why. So in the next section, we're going to consider the possible reasons that employees may not want to return to the office and the points that employers need to be considering when presented with these issues. So on this slide, I put on a couple of scenarios, a couple of reasons why employees may say they don't want to return to the office. So the first employee may say that they don't want to return to the office because they're worried about public transport, it's crowded, they don't want to catch COVID on the bus. It may be that the simple way of resolving this issue could be allowing that employee to travel into work at different times. So perhaps starting later or earlier or finishing later or earlier to avoid crowded rush hour transport. But if this isn't suitable for the employer's business, or if the employee still refuses to return to the office, in this kind of scenario, if the employee's stated place of work is the employer's office and they still refuse to come in, they'd be refusing a reasonable management instruction, and this may be dealt with under the employer's disciplinary policy. The next scenario, perhaps the employee will say that working from home suits their personal circumstances. perhaps they feel that they work better from home, or perhaps, well, I know a lot of people got lockdown dogs, perhaps they need to look after their dog now. Again, whilst it's helpful for employers to sit down and understand their employees' reasonings for wanting to stay at home, again, in this scenario, the employee would be refusing reasonable management instruction, and the employer could deal with this under their disciplinary policy if they saw fit. Turning to the final point on this slide, it looks quite a lot like the first point on this slide. In this case, the employee says that they're anxious about returning to the office because they're anxious about being in the office and surrounded by so many people and the risk of catching COVID in the office. On the face of it, it seems that the employee is again refusing unreasonable management instruction. However, in this kind of scenario, the employer should be wary of whether the employee's anxiety could potentially be a mental health issue, because if so, the employee may be considered to have a disability under the Equality Act, and this would trigger further obligations for the employer to consider. And in fact, there are quite a lot of possible scenarios that could arise with employees being required to return to work, which could trigger discrimination issues under the Equality Act. So I think it would be helpful just to have a quick revisit of the Equality Act before returning to look at these issues again in more detail. The Equality Act then is concerned with discrimination and harassment in respect of the characteristics shown on screen. So the protected characteristics under the Equality Act are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. And there are many types of discrimination, and we could spend hours and hours talking about the Equality Act alone. But the one that I want to focus on today is indirect discrimination, because I really think this is the one that's going to be most relevant to employers as they begin to require staff to return to work. So, indirect discrimination in an employment setting is where an employer puts in place a provision, criterion, or practice across a workforce, and there's then an employee in the workforce who has a protected characteristic. And that employee could suffer or does suffer a disadvantage as a result of the provision, criterion, or practice put in place by their employer, because they have a particular protected characteristic. And if the employer can't show that the provision, criterion, or practice is a proportionate way of achieving a legitimate aim, then that employee would have suffered indirect discrimination. So really, indirect discrimination is concerned with acts or decisions or policies, like potentially a requirement to bring people back to the office, which isn't necessarily intended to treat anyone less favourably, but which in practice has the effect of disadvantaging a group of people because they have a particular protected characteristic. And then where such an action disadvantages an individual with that characteristic, it will amount to indirect discrimination if it cannot be, if the provision, criterion, or practice can't be objectively justified by the employer. And I won't linger over how employers can objectively justify provisions, criterion, and practices. It's a complex subject in itself, but it's more of something to be aware of at this stage. So indirect discrimination applies to all of the protected characteristics I previously discussed, with the exception of pregnancy and maternity. But if an employer has a provision, criterion, or practice in place which affects an employee who has a protected characteristic of disability, then there's a further issue for employees to consider, and that is reasonable adjustments. So if provision, criterion, or practice of an employer disadvantages a person with a disability, the employer will have a duty to consider making reasonable adjustments for that employee. So they'll need to take all reasonable steps to avoid or mitigate the the disadvantage for that employee. Okay, that was quite a whistle-stop tour of Equality Act and indirect discrimination, but I think now we're better prepared to deal with the scenarios on screen. So if we return to our original question of how employers might deal with an employee who says they're anxious about returning to the office, if the employee's anxiety is a mental health issue or amounts to a mental health issue under the Equality Act, it's worth saying that not all health issues will amount to a disability under the Equality Act, but for our purposes, we'll assume this one does. So if this employee has a disability under the Equality Act, the requirement for the employee to return to the office would be a provision, criterion or practice put in place by their employer. And if that employee were then subjected to or threatened with disciplinary action, then they will have been disadvantaged by the policy of their employer. And this could amount to indirect discrimination in relation to this employee. And because this particular policy disadvantages a person with a disability, the employer would then have to consider making reasonable adjustments for that employee. And it may be in this context that a reasonable adjustment could be allowing that employee to remain at home. And similarly, with the next scenario, if an employee refuses to return to the office because they're a vulnerable person, because they have health issues that are potentially comorbidities with COVID, like someone who was previously told to shield, it's possible that any of those underlying health issues could also amount to a disability under the Equality Act. And again, disciplining this kind of employee for not returning to work could amount to indirect discrimination. And again, the employer would need to consider making reasonable adjustments for this employee as well. So these are just some of the scenarios or reasons that employees may say that they don't want to return to the office. But hopefully the examples that we've discussed demonstrate that it's really important to fully understand each individual circumstances in order to identify early whether the reason they don't want to return to the office is linked to a protected characteristics. And understanding it early should therefore help to avoid or mitigate any discrimination issues arising. Flexible working requests, our next topic. After more than a year of enforced working from home, I think it's likely that when employees are required to return to the office, employers might expect an influx of flexible working requests, as some employees try to retain some or all of their working from home arrangement. But what is a flexible working request? So a flexible working request is something that an employee can make once they reach 26-week continuous service. And employees can request a change to their hours of work, the times when they're required to work, so starting earlier or starting later, or a change to their place of work. So for example, a request to work from home. Employees can make one request in any 12-month period, and then once employers receive a written flexible working request, they then have 3 months to consider the request and then deliver the outcome. Employers don't have to accept the flexible working request, but they can only reject flexible working requests on certain grounds that are set out in statute. I won't run through all of the statutory grounds, but they're predominantly business reasons for rejecting a flexible working request. So employers may think that granting the flexible working request could result in an additional cost for the business, or impact on quality or performance or ability to meet customer demand. So predominantly business reasons for rejecting the request. But as I said, I think it's reasonable for employers to expect an increase of flexible working requests. And I think this begs the question of how employers are meant to deal with an influx of, or an increase in numbers. It's one thing to receive one flexible working request, it's another to deal with 50% of your workforce making a flexible working request. So when an employer receives a flexible working request, they're required to judge whether they can accept the flexible working request based on the situation that the company finds itself in at that particular moment in time. So, for example, if person A makes a flexible working request and the employer looks at their business and finds that they have no statutory ground to refuse it, and then they should accept it. But then a couple more people make flexible working requests, and then by the time it gets to person Z, the employer looks at their business and thinks, actually, we've got a statutory ground of refusal now, a business reason for refusal, then the employer doesn't have to accept person Z's flexible working request, even if person Z made the same flexible working request as person A. So making a change for one person doesn't mean that employers have to make the same change for every person if the same request is made. So essentially, employers need to be treating employees fairly, but on a first come, first served basis. So as a recap, flexible working requests are a right gained on 26 weeks service. Employees can make one request in any 12-month period, and employers then have 3 months to consider and deliver the outcome to the request. But as a sign of the times, I think, the government are at present in consultation and reviewing flexible working requests and the requirements as they stand. And they're considering whether to make flexible working requests a day one right. So employees may be able to make the request on their first day. They're also considering whether employees should be allowed to make more than one request in any 12-month period. And they're also considering whether they should shorten the time frame in which employers have to deliver the outcome. It remains to be seen whether any of these changes are affected by law, but either way, if they are, I think it will add more pressure to employers, as will any increase in flexible working requests. And I think that really dealing with flexible working requests is time consuming and may distract from the operations of the business. So I think it would be very helpful for employers to consider how they can head off flexible working requests at the outset. So employers might consider doing surveys of their employees to gauge the mood. I know here at Gowling, I have completed many surveys, but in the end, management have put in place an agile working policy, which requires us to be in the office 50% of the time. So that means that we retain some of the benefits of working from home, like work-life balance, but also have the benefits of being in the office and collaborating with team members. And I think it's working well so far. And I think, or I can imagine, that it's headed off a few flexible working requests. So I really think that taking steps to anticipate employee preferences early may head off and having to deal with an increase in flexible working requests down the line. Moving on to our final section, as promised, I'm now going to run through some of the hot topics that we've been receiving queries about in our offices. EPBs may be topics that you have faced or may face in your business in the months to come. So the first question we get quite a lot is whether employers can require employees to be vaccinated. And I think the answer here is no. Most employers can't require employees to be vaccinated without incurring a significant legal risk. Currently, only regulated care homes will be able to legally require workers to be vaccinated from the 11th of November onwards. And our discussion today has been focused on more typical office workers. Employers should also be alive to the fact that requiring employees to be vaccinated as a condition to providing work could also amount to a repudiatory breach of contract, entitling the employee to resign and then perhaps claim constructive dismissal. And also, you may be able to see from our earlier discussion that any mandatory vaccination policy risks possibly indirectly discriminating against employees with certain protected characteristics. So, for example, in the context of disability again, some of the vaccines in production aren't suitable for people with suppressed immune systems. Some people can't have vaccinations because of certain allergies that they have. And if the underlying health reason why an employee can't have a vaccine amounts to a disability under the Equality Act, then it's easy to see that any policy that requires employees to be vaccinated could disadvantage this kind of employee on the basis of their disability. And again, as this kind of employee is being disadvantaged because of a policy as a result of a disability, the employer would then need to consider making reasonable adjustments for that particular employee. In a slightly different context, it's possible that some religions could prevent an employee from having a vaccine. It's also possible, although not tested, that an anti-vaccination view could amount to a philosophical belief under the Equality Act. Therefore, requiring a person with a religious belief or philosophical belief of this kind to have a vaccine may then disadvantage them and result in indirect discrimination again. Okay, the next question we get quite a lot is whether employers can inquire about staff vaccination status. I think it's fair to say that quite a lot of people would feel safer if they knew that the person next to them was vaccinated. But collecting data about employees' vaccination status is a sensitive issue. It needs to be considered carefully because essentially what you're collecting is personal data. And the Information Commissioner's Office has issued guidance on this point. And they've said that an employer's reason for checking on or recording people's vaccination status must be clear, necessary, and transparent. And it should also be determined by the sector that you operate in and the kind of work that staff do. Therefore, whilst employers running care homes may be able to justify inquiring about vaccination status, I think it's unlikely, unless there are any very significant health and safety risks, that your typical office environment, in your typical office environment, that an employer could justify making these kind of inquiries. The final question that we get quite a lot is whether employers can require employees to wear face coverings. As James said earlier, Boris has hinted at a possible plan B over winter if things don't go very well that requires us to wear masks inside. But at present, there's no requirement for us to wear them. Employers do have their own autonomy and may put a policy in place requiring employees to wear masks. But as at present, there's no guidance mandating masks, if employers are going to enforce a policy like this, then they really should start by considering in the first instance whether it's reasonable to ask employees to wear a mask. And this is where things like risk assessments are important, because if the outcome of the risk assessment doesn't suggest that wearing masks is appropriate, then it will be difficult to take action against an employee for refusing to wear one. However, even if you can establish that the requirement to wear a mask is reasonable, it would still be very important and very sensible for employers to ask why the employees aren't wanting to wear their masks, because the reasons will vary from person to person, and the employers need to be alive to whether any of these reasons, again, could relate to a protected characteristic of the employee. Because, for example, in the context of disability, again, if a particular employee has a respiratory condition, which makes it difficult for them to wear a mask, any policy mandating the wearing of masks could inadvertently disadvantage this kind of employee with a disability. And again, the employer will need to consider whether it can make reasonable adjustments for that particular employee. Okay, that rounds up the topics that I planned to discuss today. I think the summary of what I've talked about is that it's likely or possible that when employees are required to return to the office, they may express concerns, or they may express concerns about policies or procedures that are put in place on their return to the office. But really, the most important thing is that employers talk to their employees and listen to their concerns, and consider whether any of the concerns raised trigger any indirect discrimination issues or legal obligations on the part of the employer, particularly related to the protected characteristics of their employees. On that note, I'll hand back to James, and I'll be happy to answer any questions that you may have on what I've discussed.
Thanks very much, Jasmine. That was really great, really helpful. Some really interesting points for us to be thinking about there. So yeah, please do send in any questions that you have. We've got some time now to go through them. We've had one question in, which I'll ask you now, Jasmine. Somebody said they understand the position relating to disabled employees, but they're wondering about if an employee has a vulnerable relative at home, that means they don't want to return to the office. So does an employer have to take that into consideration in the same way that you described earlier for a disabled employee?
Oh, okay. So if the employee has a vulnerable relative?
Yes, that's right.
Okay. So the obligations of the employer don't extend to a person that the employee lives with. The employer's obligations at present extend to the employee themselves. So there'd be no indirect discrimination in that context. Obviously, it's a very sensitive situation, and the employer is treated as such. But having said that, there has been a recent European Court of Justice decision which suggests that associates of a disabled person might be able to claim indirect discrimination if they're affected by a provision, criterion, or practice, which would then put that disabled person at a disadvantage. And I believe there's also been a recent employment tribunal judgment applying the CCJ decision in the UK, but it's not binding. So we don't really know what the UK appeal courts will make of it. So at present, there's no indirect discrimination, but it may be something that's before the courts in the not too distant future.
Okay, great. Yeah, so one to be keeping an eye out for. Great. I have another question through, which is sort of on a similar line to vaccines and face masks. The person asking the question says they understand that, but do you have any specific concerns about testing and how that might come into return to the office? I mean, I think effectively the question there is, you know, is there anything to stop employers from testing or you know, on return to the office, or do you have any recommendations about that?
Well, they'd have to have their employees consent to do that. And again, any of the results would again be personal data. So the same kind of issues arise in terms of how employees deal with that data, and whether whether they can justify doing it.
Yeah, I think that's right. I think, especially given the current context, you know, I think testing to come to the office is probably unlikely to be necessary, you know, for the typical office worker. So you need to be thinking about why you specifically need to test in the current climate. But as Jasmine has touched on, I think that could change in the future. But yeah, I think the other key point, as Jasmine said, is yeah, the data protection point. And then we've had one more question come through, which I'll just ask you as well, Jasmine, which is, so we've talked about sort of vaccination information in sort of your current employees, but do you have a view on whether that applies in the same way to recruiting new employees or future employees? Sort of, the rules on whether you can hold that data and ask people.
Asking people whether they have been vaccinated before they come to interview, essentially.
Yeah, I think so. Yeah.
If an employer is saying that only people who are vaccinated can come to interview, then the concept of indirect discrimination applies equally to current employees of the employer as it does to prospective employees of the employer. So this kind of policy would be indirectly discriminatory against that kind of job applicants. So I wouldn't advise employers to do that particularly.
Great. Okay, thanks, Jasmine. Well, we haven't got any more questions, so hopefully everyone's enjoyed it, and you've already answered them all with your very thorough speech. So thank you for that, Jasmine. Before we close the webinar, I just want to remind everyone again about the data protection webinar we have at the same time tomorrow. So hopefully you can all join that one. And also just to say that there will be that feedback form popping up after the webinar. So if you do have 2 minutes, we'd really appreciate you giving your thoughts. So otherwise, I'll just say, thanks again to Jasmine, and hope you have a great day.